Just to go along with Rob's comments today, just as a little bit, basically, I think last year, September was Rotary Vocational Month. I don't know, maybe I'm mistaken on that month. I just know it's usually in the big, get down toward the end of the year. One of the ways that one of the more, I will say, unsung ways that you establish peaceful relations is to have a mechanism that is relied upon, is trusted, and is a process for resolving disputes, because we all have disputes eventually. Whether those are civil in nature, which is what I deal with, or whether there are disputes about whether you have violated some rule by which we all live, we have to have a way to deal with them in a peaceful manner and in a rational manner, or you end up basically resolving them by violence. So as an attorney, as an officer of the court, and as part of the overall process of judges and law enforcement and everybody that's involved in the system, that is our ultimate goal. And that's our ultimate job, is to give people a forum for resolving their disputes peacefully, and to reinforce that that system is ultimately fair. You may not always like an individual result, but the process is fair to everyone who finds themselves involved in it. So part of that second function is to try to educate the public who maybe don't have a lot of interaction with the legal system about how it works, maybe to clear up some things that in popular culture or whatever, unfortunately television is not the best source for what actually goes on in a courtroom. I can't watch lawyer shows. My dad religiously watches Law and Order, and every time I see them, I'm like, Dad, you realize those prosecutors would have been disbarred 3 times over? Yes, it looks good for dramatic effect. That's not the way we do our job. So, a couple of years ago, I found myself in front of the Virginia Supreme Court, not voluntarily, or at least my client didn't find themselves there voluntarily. I represented the party defending a trial court decision in Warren County, and that was my first time. I've done plenty of things saying to the Supreme Court, "Nah, you don't have to pay attention to this." The court did it right, and never had the court accept the case, except for 2 years ago. So it ended well for my client. They got a unanimous decision affirming the trial court's decision. It's a published decision, which means it has precedental value, which is a nice little career highlight for yours truly. So we're going to use that as kind of a springboard to talk about probably a part of the process you don't deal with a lot, which is the appellate process. So here goes. One of my favorite quotes from Wolf Hall by Hilary Mantel won the Booker Prize the year it was published. "Leases, writs, statutes, all are meant to be read, and each person reads them by the light of their self-interest." Okay, who am I? I've been an attorney with Joe's office for nearly 20 years. He hadn't fired me yet, so that's because he never watches these programs. I've been, half the time he doesn't even know I'm doing them. Do what?
He's not up yet.
No, not at all. I've been licensed for 20 years, a little over 20 now. My practice is entirely civil in nature. I do not do criminal law at all. And I self-identify as a dirt lawyer, which means that if you ask me what I do, my first response is whatever Joe tells me to do, and then the second response is, well, I mostly do anything involving real estate, from litigating real estate cases to negotiating transactions. I also help with our land use and development practice, that sort of thing. So, and I've been doing that pretty much my entire career since I've been with Joe here in Front Royal. Before we get started, you got to have, of course, the usual disclaimers. This isn't legal advice. It's probably not even entertaining, but if there's something you want to talk about, if you have a situation involving the law, you need to schedule with the counsel of your choice. Today I'm only going to talk about the Virginia Supreme Court and my experience and my perceptions of it. Virginia does have another appellate court, which is the Virginia Court of Appeals, which hears primarily a lot of criminal and domestic law appeals first. As you may be aware, our own Judge Clay Athey will be part of the Court of Appeals. As a matter of fact, I think he's already taken the oath and is now sitting on that bench. As I said, this talk doesn't reflect the views of my office because they don't even know I'm doing it. So, okay. First of all, how does the Supreme Court decide to take a case on appeal? It's real simple. Two justices got to decide to hear it, and that's it. Until last year, you only had to convince one. The year that I went to the Supreme Court, you only had to convince one justice that there was something interesting enough about your case to take what we call cert, or give you what's called a writ of certiorari. Okay? It doesn't mean that the justices who want to hear your case have decided something is wrong. It just means that for whatever reason that you will never know, they found something interesting about it. What is the purpose of the Supreme Court hearing an appeal? Well, there's basically two. One is to correct reversible error, and that's defined as, look, no trial goes perfectly, and no judge gets everything right. However, there are some errors which affect the final decision, and one of the jobs of the appellate court is to make sure that if there's a mistake done, and were it not for that mistake, that there's a good chance the result would have been different, those have to be reversed. You have to send it back to the trial court and say, you did this wrong, do it right, and tell us how that affects your decision. Sometimes it does, sometimes it doesn't. Note that appellate courts don't hear new evidence. Basically what you do is you freeze the record before the trial court in time, and they look at that and decide whether there was anything there that they need to address. The second thing they do, which is I want to talk a little bit about, is they make pronouncements of law applicable to that case and potentially beyond. Now, many of you have probably seen this above quote. Judges don't make law, they merely act as an umpire. You hear it primarily in, if you ever watch committee hearings of judges in front of, generally the federal courts, where you hear that line all the time. We're calling balls and strikes. We're just the umpire. Well, in my humble opinion, that's only partially accurate. And in fact, it's so partially accurate that it can distort the public's view of how the judicial system works. Here's why. Courts, if you think about it, when you go to court to resolve a dispute, by their very nature, they're rendering a binding decision on you. And that meets the definition of a law. And straight out of Black's Law Dictionary, a law in its generic sense is a body of rules of action or conduct prescribed by a controlling authority and having binding legal force. If you don't think that your local trial court makes law, then disobey one of their court orders and see what happens. You will find out very quickly that they have binding legal force. And as a further example, the case I was involved in, and I have copies of the slip opinion if you want me to. I thought about, when I originally did this, I was going to copy and put them on the tables, and I thought, why waste the paper? By the way, the reason we call it a slip opinion, because if you read it, you slip into unconsciousness. But if you want it, I can email it to you. I can make it available. That case was decided entirely on what we call common law principles. There were very few statutes involved. They didn't control the case. So what is common law? Well, it's the body of law that is made up of legal principles originating from old case decisions In other words, common law is judge-made law. And judges absolutely make law, as does the General Assembly, and as does the governor and the executive agencies. But here's the difference: to be considered legitimate by the other branches and the public, laws are made differently by the different branches of government. And that, I think, is what we're trying to say when we talk about judges don't make law. There's a certain species of law that they don't make, or it's not appropriate for the judiciary to make. But you got to think about our system. Our system is basically made up of three branches: the executive, the legislative, and the judicial. Each of them make law. They make decisions binding on you of greater or lesser importance. But how they go about it and how they're allowed to go about making those rules is very, very different depending on the institution. And that, I think, is essential to understanding how our system works. So we'll talk about the characteristics for a second of judge-made law. First thing is, judges only have the power to decide actual controversies between specific parties. In other words, if Judge Sharper's sitting here, he's not going to go around to your table and tell you you're doing something illegal, because no one's asked him. And also, even if you ask him, he'll say, I don't make advisory opinions. So someone has got to say, hey, this person broke a rule and it affected me in some way. And the other guy says, no, I didn't. And then if you do everything right, then Judge Sharp will hear what you got to say. A judge cannot and will not make legal pronouncements without an actual case or controversy. By contrast, legislatures and administrative agencies, they can develop laws without a specific controversy. The legislature makes laws all the time that no one's asked them to make. And they don't arise out of a dispute necessarily. Sometimes they do. There's my old joke about the brother-in-law rule, which is a legislator's brother-in-law gets in trouble for something and he gets upset, calls his brother-in-law, and they change the rules. But and sometimes when you see an odd rule, you kind of feel like the brother-in-law principle's probably in play. But the point is, the judiciary, to make a decision, has to have parties come before it and say, we have a dispute, we need resolution for it. The legislature and the executive does not need it framed like that. The second thing that makes judge-made law unique is they can only decide cases based on facts established using fairly rigorous rules of evidence. You've probably heard some of these. You've heard things like hearsay. You've heard of, we have rules against allowing hearsay evidence in. We have rules, and again, all rules are subject to exceptions, of your past bad acts cannot be used as evidence to show you did this bad act, most of the time. Like I said, there are exceptions. There are exceptions, but that's the general rule, is that you can't, if just because I shoplifted a piece of bubble gum when I was a kid, should not be used to show that I embezzled money now. You know, the idea is that it's too attenuated. But if you contrast that with the legislature, when they make law, yes, they're supposed to have a rational, but the bottom line is that when a legislature makes laws, it's supposed to be on a quote-unquote rational basis. However, and they do have hearings sometimes, they do take in things, but the notion of evidence is a loose concept. Basically, they can hear hearsay. They can hear stuff that has no corroboration, no corroborative evidence. They can make laws decided on things that a judge would never make his or her version of law on. And that's the difference in the nature. Doesn't mean that legislatures are sloppy. It's that legislatures have a different mandate, and legislatures are a different institution and have a little different ways of doing things. Also, the final thing that makes, one of the things, there are probably others we could talk about, is judicial reasoning is deferential to state and federal constitutional language. It's deferential to laws properly created by the other two branches and to already decided appellate cases. By contrast, if the legislature doesn't like a ruling that the appellate court makes, unless it's a constitutional principle, many times it can create a new law overruling that decision, and our legislature has done that. The Supreme Court said, well, we're interpreting your law to say, well, this is what it says. Legislature says, I don't agree with that. So they go pass a law that says, no, now this is the law. And legislature's like, okay, the judiciary's like, okay, that's your prerogative. So again, whereas if you're ever involved in a court case and you look at a judge's opinion or a judge's order, a lot of times you're going to see them not make new pronouncements, just what they think is right. You're going to see citations to statutes. You're going to see citations to court cases that either they're obligated to apply or ones they find persuasive. But it's a very small c conservative way of rulemaking. So yes, Virginia, there is judge-made law. Now, how does it get created? Well, in its simplest form, it gets created when a trial court renders a final decision, which is an appeal. So if you have a dispute in front of Judge Sharp, he renders his final decision. If you don't appeal it to the Supreme Court, or the Supreme Court doesn't take it, that's the law of we call it the law of the case. Those are the binding rules of those parties as to that case. It tells you what you will do, whether it's to refrain from doing things, whether it's to pay money in a judgment, or whatever. Now, but understand, beyond the parties, the trial court decision has no precedential value, which means, okay, Judge Sharp rendered a decision, but Judge Madden, the newly appointed Judge Madden, doesn't have to follow what Judge Sharp said. He can have a different take on it. But both of them have to defer to decisions of the Virginia Supreme Court if they happen to apply to the facts of the case. So, if we're not talking about your particular case, judge-made law starts with a trial court decision that one or both parties don't like, which usually that's both parties. One or both of the dissatisfied parties then must file a notice of appeal within 30 days after the judge enters their written ruling. As I said, otherwise the trial court's decision is the law. Now, the party that noted their appeal to the whichever appellate court, they're called an appellate. And they have a limited time in which to make sure the trial court record is complete and to file their petition for appeal, which is about 25 pages in length, maximum. And by the way, in civil cases, unlike criminals, a little different. Civil cases, you're not entitled to a court reporter, for example. You have to pay for that, and you have to know ahead of time whether you're going to have that expense. And court reporters aren't cheap. Your lawyer, if you decide I want to appeal it, well, they got to go examine the trial court's record and make sure that all the pleadings and everything that was there is there. And they work with the circuit court clerk's office to do that. But if there's something missing and your lawyer didn't catch it, that a lot of times it's on your lawyer. Blaming the circuit court clerk's office is like blaming the dog for eating your homework. Whether it's true or not, it's not going to fly. So again, in civil cases, there's a lot of work. In criminal, I think that, again, the process is a little different because different rights are involved. Now, after the petition for appeal was filed, the party who didn't have an objection to the trial court decision, which is called the Appellate, and that's who I represented in my case, has a certain time in which to file a brief in opposition. This also can't be any more than 25 pages in length. So, on top of that, the appellant in Virginia has the right to go to Richmond. So once they filed their brief, once all the briefs are filed, the appellant can go to Richmond and make a 10-minute speech to what's called a writ panel, which is about 3 or 4 of the justices that are sitting and hearing, in an attempt to convince 2 of them to accept the appeal, what's called grant certiorari or grant cert for short. If the appellant can't convince 2 justices to grant cert, case is over. And in my 20-year career, all but one of my cases have died. You know, all the cases I've been involved in have stopped at this point in the process. But suppose the Supreme Court does grant cert, then what? Well, now the parties must create and index those portions of the trial court record which each side believes are important to the appeal. It's called an appendix. First, you remember, you start with the big glob of that is the trial court record. And then you got to do an appendix, and you got to work with the other side about which particular documents you want the Supreme Court to take a look at. This is the Supreme Court. One of the things that over the course of my career that you read, they more and more demand precision out of the attorneys. It's not just, I don't like the decision. Why don't you like the decision? What particular thing did this judge do that you think is either a reversible error or a principal law we need to reconsider? And they want you, it's not throw stuff at the wall and see what sticks. Okay, so you've got cert granted, you've done your you're working on your appendix. Both parties then get to file additional written briefs, which are up to 50 pages in length each, in a format mandated by the Supreme Court within certain deadlines. The appellant also, in addition to that 50-page brief, they also get to do a shorter brief, and I think it's, I can't remember, it's 15 or 25 pages, but they can do basically rebut it as rebuttal to whatever the appellee says in their brief in opposition, or their appellee's brief. So by the time oral argument takes place, each side has written at least 75 pages of disposition about their case. And the justices and their small army of clerks read all that stuff before you even show up. So finally, you've killed all these trees, you've done all this research, you've timely filed it, the courts have read it, the clerks have read it, and finally you're at you're at oral argument in front of the full court, usually, unless a justice, for whatever reason, is unavailable or maybe they're conflicted out of the case. And by the way, they don't come to you, you go to them. So you're taking a trip to Richmond. So the Court of Appeals, the different Court of Appeals will sit at different places in the Commonwealth. Supreme Court, you go to them. So you go to make oral arguments. Each side only gets 15 minutes.
Wow.
So you've taken hundreds of thousands of pages, even in a normal case, civil case, and you got 15 minutes. And it ain't 15 minutes until someone politely asks you to stop. That's not the way that's not the way oral argument works. You will stop at 15 minutes. If you're in the middle of a sentence, you will stop. During that 15, also, to make it even more fun, during that 15 minutes, these are not, as one experienced lawyer told me, these are no longer 7 wax statues that sit there impassively while you talk. This court is active, which means you can expect to field questions from any of them on anything regarding your case. And you don't get extra time. If justice questions take up your 15 minutes, too bad. So again, lawyers know this, so they have to strategize about, okay, you assume you got maybe 30 seconds to get something out of your mouth, so make those first couple of sentences count. So there's that. And oh, by the way, if you're the appellant, while you can have rebuttal time, you have to budget your 15 minutes, and you got to keep track of it. They don't do it for you. So you got to kind of keep in your head, okay, if I want 5 minutes left, well, I'm at 10 minutes. Well, I need to tell the court I'm sitting down now, and I'll reserve the rest of my time. I've seen lawyers not do that, and then they had 30 seconds left. So we have all this, we go through this, and they don't rule from, usually they don't, I don't think I've ever heard them ruling from the bench at the time. They say, thank you, next case, and the next group of lawyers, because normally what they do is you have a day of nothing but oral arguments, and it's 30 minutes at a time. And once one group's done, you move your stuff, next case comes up. It's just very almost factory-like. Finally, at some point after the hearing, the court will issue its decision, which I said is called a slip opinion. And as I said, they call it that because you'll slip in unconsciousness if you read it. If you really need sleep aid, I'll give you my brief that I wrote. You'll be catatonic. That's a copy of the first page. So the opinion is obviously important to the parties who spent this time and money doing it. How is it important to everybody else? Well, if the Supreme Court designates it for publication, meaning it's been indexed with a formal citation, then its precedents, which other parties cite in legal arguments and state court trial judges must apply, if it's applicable. For example, the case I was involved with was called Denton versus Browntown Valley Associates. Its citation is 294 Virginia 76, 803 Southeast 2nd, 490, 2017, and that's the way you cite it. The Virginia refers to the state index. The Southeast 2nd there's also regional indexes, and the way they group the states makes no sense sometimes, but we're in the Southeast. Why we're not in the Atlantic is beyond me, but still. Those are regional of all the states in that given region. They're important decisions, and basically that's for the out-of-state lawyers. When you cite to a state court, you cite the Virginia site, but you can do both. But that's what it looks like. That's when you see those in your cases or whatever, you wondered what that was, that's what it is. Congratulations, you just participated in creating judge-made law. And lawyers are ethically and professionally obligated to be familiar with published decisions applicable to their cases. Otherwise, you and your client, possibly the state bar and your malpractice carrier, might be having a difficult conversation. If it is not designated for publication, and not all cases are, they're called unpublished. You can still find them, you can still cite them, but they're treated with less deference. You're not expected to be familiar with unpublished decisions. If you're going to cite one, you are obligated to provide a copy to the trial court and the opposing lawyer so they can review it and make argument based on it. So, what are the costs involved in appeals? The short answer, in the civil cases, a lot. It's not unusual for the appeals process just by itself, assuming you go all the way from noting an appeal to oral argument, to cost a party over $50,000 in attorney's fees. That doesn't count the fees expended at the trial court. So unless there is a fee shifting clause in a contract, a statute, or a special rule in your case, in civil cases, parties cannot recover their attorney's fees from the other party. It's called the American rule. And it is probably the single most disappointing thing when I talk to clients. They hear all the things. They're like, well, can I recover my fees? Well, what's the case about? Is it about one of these exceptions? No. Do you have a contract? Yeah. Does it have a fee shifting clause in it? No. You're SOL. You're paying your own freight. Okay. Let's see. I think I went the wrong way. Okay. Final impressions. While it was a lot of hard work, research, and writing, because this was a case that I took from initial intake in the office all the way. And it was about 7 years long. But most of that was because it had laid dormant for a few years and then the parties decided to activate it again. But I would say it's probably a couple, 3 years of actual time spent. I would recommend that every citizen make an effort to go, and these are public, you can sit and watch, an appellate court oral argument. It will make you appreciate the seriousness of the law, and you will appreciate the hard work and preparation that competent lawyers do. Even the ones that aren't successful, they still have put a lot of work into it. Appellate oral argument is different than argument before a trial court, which I do sometimes recommend you go sit in on the ones that are public. but it's different than my normal style, but it did impact my argumentation style. I try to be a lot more succinct, unlike today, in my arguments. And I'm firmly convinced after that experience that research and investigation at the beginning of a representation is money and time well spent. Sometimes it's hard to convince my clients of that, but I think at the end they begin to appreciate looking at a case ahead of time always nets them benefits at the end. Finally, online resources. The Virginia Judicial System website, you can listen to oral arguments. They have oral arguments, I think, going back to the 90s, including mine is on there somewhere. You can also get emails of you can get emails so they'll notify you when they do writ panels and what cases are up on writ panels, which ones they've accepted. They'll send you copies of both published and unpublished decisions if that's what you want. So you can also, by the way, if you have a case, you can also go online and you can check the status of your case, whether it's circuit or general district court or whatnot. J&D is the exception because that stuff has to remain confidential. So you can at least see where your case is at. You know, has an order been issued? Maybe you had a motion or something. So there's a lot of good information on there if you're curious. Like I said, you can find cases at any level. You can read slip opinions. You can listen to recordings of past oral arguments. Questions?